How do you enable a country wounded by serious human rights violations or wartime violence to rebuild itself? How to live with this legacy, restore justice, and overcome the divisions created in the past? How to move towards a rule of law that is able to protect every member of society? This is precisely the objective of transitional justice. The term refers to the entire set of judicial and non-judicial strategies that societies use to deal with the deep legacy of violent conflict, mass crimes, or dictatorship. These strategies come into play in situations where the balance of power has been upset and where the people have lost confidence in the system. What are the foundations of transitional justice? In 1997, the principles of this special justice were formally set out in a report presented to the United Nations by the French jurist Louis Joinet. The report is intended to strengthen the fight against impunity and bolster the rights of victims at the international level. The end of the Cold War and the accompanying democratization process have ensured that the issue of impunity is front and center. In 1993, the Vienna Declaration vehemently condemned grave human rights violations, such as the crime of genocide, ethnic cleansing, and systematic rape. It recommends creating and strengthening various instruments in order to end impunity for the perpetrators of such crimes. It was in this context that the Joinet report was drawn up, proposing a set of principles for the protection of human rights through the fight against impunity. These principles are the right to truth, the right to justice, the right to reparation, and guarantees of non-recurrence of violations. In 2020, the UN proposed the addition of a fifth principle, the duty of remembrance. How is transitional justice implemented? Countries in transition make use of a combination of different tools to abide by these 5 principles. To speak the truth. What does the right to truth involve? The right to truth is the right of every victim to understand the true nature of the violations committed. This is also a collective right. By being aware of what has happened in the past, a society can help prevent such acts in the future. This right, which can constitute a significant step towards reconciling a society, is principally implemented by national and supranational commissions of inquiry. In South Africa, for example, the Truth and Reconciliation Commission, established in 1995 by then-President Nelson Mandela, played a key role in the country's transition towards democracy. To judge. How can the right to justice be exercised? This right means that every victim has access to effective and efficient legal remedy, in particular, to see justice served against those suspected of the crimes of which they are the victim. This translates into an obligation for states to rapidly conduct judicial inquiries into violations committed and to prosecute, try, and convict those responsible. It often consists of formal procedures intended to deliver justice after widespread crimes. Methods of alternative dispute resolution, ADR, might also be used. This is often based on traditions or informal processes such as mediation. Where national courts are unable or unwilling to assume this responsibility, international courts or hybrid courts may exercise subsidiary jurisdiction. Within a hybrid court, the bench consists of international and national magistrates. This is, for example, the case for the extraordinary chambers in the courts of Cambodia, ECCC. Third countries can also intervene on the basis of universal jurisdiction. Amnesties are a controversial solution. Criticized for allowing impunity, they might, however, help alleviate tensions when linked to processes of disarmament, the search for truth, or reparation. This was the objective of the amnesty program in Niger, offered to the former fighters of the jihadist movement Boko Haram, once they had agreed to lay down their arms. To repair. How can victims be compensated? This is about the right of victims to be compensated for the harm they have suffered in the form of restitution, compensation, or rehabilitation. There is also a collective aspect to this right. Official recognition that restores the victim's dignity, for example, is part of reparation mechanisms. This is at play in Myanmar, where investigators of the United Nations in 2018 accused the military of having carried out acts against the Rohingya with genocidal intent. To reform. How to ensure that history doesn't repeat itself. The restructuring of the political system and institutions of a country plays a fundamental role in the process of guaranteeing the non-reoccurrence of violations. In practical terms, disbanding armed parastate groups, accompanied by reintegration measures, removing senior officials involved in the violations committed, and repealing laws and jurisdictions that facilitate impunity. Efforts to remove government officials of former communist regimes in Eastern Europe are an example of the use of so-called lustration processes. To remember. How do we fulfill our duty of remembrance? In order to not repeat the mistakes of the past and to prevent negationism, it's imperative that the atrocities committed do not fall into oblivion. This duty of remembrance relies on protecting archives, giving a voice to victims, and developing a collective memory. This can be achieved through educational, cultural, and artistic initiatives, commemorations, and the creation of places of remembrance. To give just one example, the Museum of Memory in Chile documents the horrors of the dictatorship and attempts to stimulate reflection on its historical context. What are the challenges of transitional justice? In most cases, it's a process of an overall political transition. Its success will depend on taking into account the unique characteristics of each situation, deploying tools at the right time, and involving large sections of society in the reform process. For example, Rwanda's decision to rely on traditional people's court to try the perpetrators of war crimes has increased the population's support for the justice process. Between 2001 and 2012, these gacaca courts treated over 1 million cases, and they also favored the reintegration into the communities of thousands of genocide perpetrators. Given the complexity of the different transitional situations, it's vital that the major actors in the process strike the right balance between the various tools at their disposal, between justice and peace, between preserving the memory of the past and looking into the future. This is how they can learn from the painful lessons of the past to better protect the rights of every individual in the future and live together in harmony.